1 and 5 is Advocate Motsoane. Representing accused or applicant number 2 is Advocate Volmarans. Representing accused or applicant number 3 is Ms. Gilling. Representing accused or applicant number 4 is Advocate Jorgensen. Ms. Lamini is assisting with the interpretation of this matter. Matter was adjourned today for purposes of practice to make submissions in relation to the application to be released on bail brought by all 5 accused or applicants.
Confirm your appearance.
May it please the court to worship, I do confirm my appearance on behalf of applicant number 1 and number 5 in these bail application proceedings.
May it please the court to worship, I confirm my appearance on behalf of applicant number 2.
Court, please, as your worship, on behalf of applicant 3, confirm my appearance.
May it please the court to worship, I appear for number 4, Jorgensen P, instructed by Mr. Taylor.
I need to place on record that we are only starting at this time because of the delay which was occasioned by yourselves, in that your papers were not correct, and I had to allow you opportunity to rectify your papers, which has caused a delay, and fortunately now the papers are all ready and corrected. I must also place on record that the heads of argument by the state were only sent late yesterday. According to my computer, they were sent at 2:30, at which time there was no internet. I could not access them, so I don't know what is contained in the state's papers. I could not read because this morning I had to drive from where I'm coming from to here and had to attend to the shortcomings that were there in your papers. But be that as it may, I will allow you to proceed with your submissions and engage you wherever I can in your submissions. Whilst we are proceeding with the arguments, the applicants may be seated. I will give the floor to you, Advocate Motsoane.
As court pleases. First and foremost, in respect of the introductory remarks by the court, the responsibility is being owned for the mistakes that the court had to give us the indulgence. We are indebted to the court to the indulgence. Your Worship, the argument by all parties in the matter is to the effect that, in the light of the fact that we are dealing with multiple applicants, that there will be no need to read the entire heads of argument to save time. However, one will have to draw the attention of the court to those aspects one feels are significant to be brought to the attention of the court. Your Worship, I'm not sure if perhaps it will not be more appropriate to mark all the heads of argument, or they will be marked as we are proceeding.
They will be marked as we are proceeding, but yours are creating a problem in that you have combined the first and the fifth applicants.
That is correct, Your Worship.
Yes, in one document, which would mean that I will have to mark them as one exhibit.
That is the position, Your Worship, for convenience sake.
So for applicant number 1 and applicant number 5, the heads of argument will be marked exhibit N.
As court pleases.
Thank you. You may proceed.
Your Worship, I will shoot straight to paragraph 3 of my heads of argument. As the court has indicated that the state's heads of argument were submitted yesterday, it would appear that after traversing the state's heads of argument, one has to see some authorities to clarify further issues. So under paragraph 3, Your Worship, if the following can be added, that the Criminal Procedure Act 51 of 1977 does not contain a legal definition of bail. Safe to mention in section 68 that the effect of bail granted.
Where are you reading? Where should that be added?
Your Worship, it will be added under paragraph 3.
Paragraph 3 starts by...
Before paragraph 4. Paragraph 3 reads, it is respectfully submitted that the learned authors, Lloyd et al., opine that the basic purpose of bail from society's point of view has always been and still is to ensure the accused reappearance for trial, but pre-trial release serves other purposes as well. Purposes recognized over the last decade as often dispositive of the fairness of the entire criminal proceedings. Pre-trial release allows a man accused of crime to keep the fabric of his life intact, to maintain employment and family ties in the event he is acquitted or given a suspended sentence or probation. It spares his family the hardship and indignity of welfare and enforced separation. It permits the accused to take an active part in planning his defense with his counsel, locating witnesses, proving his capability of staying free in the community without getting into trouble. So, having read the heads of the state, Your Worship, I'm of the opinion that it will be important to add the following, that the Criminal Procedure Act 51 of 1997 itself does not contain a legal definition of bail. Safe to mention in section 68 that the effect of bail granted is that an accused person shall be released from custody upon payment or the furnishing of a guarantee to pay the sum of money determined for bail. In essence, the purpose of bail can be regarded as securing the attendance of the accused while balancing the interests of justice against various rights and factors. Again, Your Worship, under paragraph 4, before paragraph 5, I found it important that reference be made in the case of, in relation to the case of Novick versus Minister of Law and Order, and another, 1993, Volume 1, SACR 194, Witwatersrand Local Division decision, as it was known then, judgment by Berman A.J. on page 197, particularly paragraph F to I, where the learned judge stated that the state is not entitled to hold an accused in custody for the purpose of investigations and so frustrate his right to apply for bail. The state, in that context, the relevant policeman, is not entitled to be the final arbiter as to whether an accused is entitled to bail or not. The case that I quoted in paragraph 5, Your Worship, is a well-known case of Goddard versus the state, wherein the accused was facing multiple charges of rape in this division, with complainants who were all primary school learners, where the learned judge in this division, Mungadi, stated that incarceration prior to a conviction with all its irreversible indignities and consequences may not be resorted to easily in a constitutional democracy with enshrined Bill of Rights. Otherwise, Your Worship, this other case finds relevance. State versus Smith and another, 1969, Volume 4, SA 175, decision of this division, and at 177 page, paragraph E to F, where it was held as follows. The general principles governing the grant of bail are that in exercising the statutory decision conferred upon it, the court must be governed by the foundational principle which is to uphold the interests of justice. The court will always grant bail where possible and will lean in favor of and not against the liberty of the subject, provided that it is not, it is clear that the interest of justice will not be prejudiced. Your Worship, I think it is important to jump to the additional reasons why bail should be granted. That would appear on page 7 of my heads of argument. Your Worship, it's common cause that before this honorable court are the founding affidavits by both the first applicant and the second applicant in paragraphs 212, 213, 214, where there are reasons given for why bail should be granted. After receiving the state papers and going through the state papers, Your Worship, particularly the paragraphs in the opposing affidavit of the state 212, 213, 214, and the heads of argument that the state has submitted, Your Worship, there is no denial that the possibility exists that before the matter can be set down for trial, the other processes will have to come full cycle, the extradition as well as the mutual legal assistance. Your Worship, it is in that context that paragraph 14 is stated that it is stated that in full compliance with brevity is the soul of the wit. We are talking about the inference that one is able to draw. So it is another reason that the bail application ought to be granted, especially because even if the court outside this jurisdiction, the requested country, that is Eswatini, even if it grants the order to surrender, those alleged fugitives will still be entitled to appeal. Your Worship, the allegation in paragraph 18, the allegation that the applicants will not stand trial, Your Worship, it ought to be, the allegation by the state ought to be considered in the context that in respect of applicant number 1, he became aware in December 2023 when he alleges that upon his arrest, it was brought to his attention that the police will eventually arrest him in connection with the death of the deceased number 1 in this matter. So up until he was arrested in at the police station, complying fully with the order of the learned magistrate, Mr. Singh. Your Worship, this allegation not.
So how can you say he was complying fully with the order of Magistrate Singh when the evidence is that he was looked for at his residence, he could not be found? That is why he had to be arrested at the police station, and later he took the police to Nzeleni, where some of his belongings were found.
Your Worship, I fully understand the court's concern. However, my humble submission, Your Worship, to the court's concern is that the concern also arises in the evidence of the investigating officer to that effect. If one looks at the affidavit that was filed, presented before the learned magistrate, Mr. Singh, the investigating officer was able to interview the parents of applicant number 1, the mother, the father, as well as the siblings, for him to say personal circumstances have been verified. This time around, Your Worship, the concern is the investigating officer is making that allegation without taking the court into full confidence. Who exactly did he speak to? Who would have given that information to him? If in the initial bail application he is able to interrogate and interview the parents, what is it that would have prevented him this time around not to do that? So my humble submission, Your Worship, is that the evidence of the applicant ought to be accepted in that regard. And again, Your Worship, the legalities, the constitutionality of the issue, of the explanation, no explanation of rights, no indication to applicant number 1, whatever he says may be used against him at a subsequent court proceedings. I think, Your Worship, that is also a concern. My humble submission is, had the investigating officer approached his parents would have confirmed. The police station would, the register was not even challenged that he was signing at the police station, that he was complying fully with the order of the learned magistrate.
But I hear you in saying that there was maybe constitutional issues, explanation of his rights and what have you. Now the question that comes to mind is, how would the investigating officer have known of Nzeleni address had the accused not supplied that address?
Your Worship, that is the allegation we make in the replying affidavit, the reliance upon the informers. It's possibly that somebody purporting to be an informer would have tendered that evidence to the investigating officer. It is against that background, Your Worship, that had the investigating officer at least obtained the statements to which people who got the information that he was no longer residing in the area were stating when they got that information and what circumstances and so on and so forth. And Your Worship, the standard in these proceedings is just on an honest, it's just on the balance of probabilities. Your Worship, in respect of paragraph 19, I think paragraph 19 of my heads of argument ought to be looked at in conjunction with paragraph 36 of the state's heads of argument. Starting with the state's heads of argument, in paragraph 36, reference is made to the case of State versus Kitticat. I assume, Your Worship, all of us has cited that case as it is locus classicus from the Apex Court. What I'm trying to draw to the attention of the court, Your Worship, is that the state is saying the court held that bail proceedings are sui generis. I fully agree. The application may be brought soon after arrest. Your Worship, my humble submission in that regard is that this case is distinguishable from the Kitticat case in the sense that the alleged incident dates back to February. There is a huge time lapse between the arrest or upon all the applicants and the alleged incident. And if the state is saying the investigations are incomplete, Your Worship, again there is concern in the sense that the state is just generic. The state is not taking this court into full confidence in terms of particularizing in the light of the time lapse between the alleged incident and the date of arrest. What is it that is still outstanding? Is it the money laundering charge? Is it the assessment and the analysis of the forensic evidential material? That is not coming from the state, except that the investigations are incomplete. It is on that basis, Your Worship, that reference is made to the case of Moi in paragraph 19, where the learned Judge Snyders, J.A., held that the delay by the state in concluding its case, taken with the accused witnesses of state case, constitute exceptional circumstances which, in the interest of justice, permit the release of the accused. In other words, Your Worship, it cannot be an excuse. This is a high-profile matter. It cannot be excused that after more than 12 months of the alleged incident, when the arrest is executed upon the people considered to be connected with the matter, there is a wild allegation without particularizing the investigation.
Are you saying it is the state submission that the investigation has not been finalized, outstanding?
Your Worship, probably it will be wise to refer to paragraph 266 of the answering affidavit by the investigating officer, Mr. Pillay, wherein he states as follows: the investigations in this matter are at an advanced stage and very strong against the applicant. My team and I took a long time to investigate this matter prior to arresting the applicants in order not to delay the matter further after arrest. This approach has yielded the results because the investigations are advanced. In a nutshell, Your Worship, it is clear, and again in the heads of argument by the state, it is clear that even if the judgment were to be handed down in this matter, the matter will not be set down for trial immediately, as there are still investigations that are ongoing.
But does this say there is outstanding investigation? The investigation are in an advanced state.
Yes, Your Worship.
Okay. What does that say?
Investigations are incomplete.
Yeah, okay.
My instructions, Your Worship, is it just says that, as the court has correctly pointed out, investigations are at an advanced stage, but it doesn't say the investigations have come full cycle, are complete.
Well, this makes one speculate could it not be not finalized because there are accused who are still outstanding, who are still to be extradited from Eswatini? I'm not here for the state, but I'm just asking because that is a fact.
As the court, please, your presumption is everybody is able to articulate himself. If that was the position, Mr. Pillay, the investigating officer, would have stated exactly in those clear terms. That it goes back to the concern that I've raised, the generic allegations. It would have helped all of us if the state was able to take everybody into full confidence and tabulate, this is X, Y, Z that is outstanding. For instance, if there is an allegation of a money laundering, probably one would think of a forensic audit report. Somebody would expect perhaps the DNA to be outstanding. So under normal circumstances, it is the practice in our bail applications, Your Worship, where the state will take the court into full confidence and say, investigations are at an advanced stage, however, outstanding is the following. It doesn't help to just generically refer to the investigations as just as being at an advanced stage.
Whilst we are on that, you are saying, citing Moy versus the state on page 10,
Yes.
that Snyder J.A. held in Moy that the delay by the state in concluding its case, taken with deduced weaknesses of the state case, constitute exceptional circumstances. What do you mean, weaknesses?
Yes, as I progress with my submissions, at a later stage I will be demonstrating to this court the impeachability of the charges that the state has preferred against the accused when we talk about the state case. Obviously, with the Moy case, as well as this honorable court, will have to adopt a holistic, expansive, integrative approach, looking at all the aspects, and then in the context of Scott Crossley, individually and cumulatively, make a determination whether exceptional circumstances have been presented or not.
Well, I'm asking this question at this point in time because in your founding affidavit, you say that the applicant number 1 will apply for discharge in terms of section 174 of the criminal procedure during the trial. It is on those bases that I'm raising this question.
Not only that, Your Worship, an averment to the effect that the state is clutching at straws in the affidavit. Probably, Your Worship, let me quickly address the court under the state case subject to serious doubt and non-existent in paragraph 28 of my heads of argument.
Yes.
Okay, my apologies. Your Worship, if one were to understand the attack on the state charges, if one looks at the state heads of argument, paragraph 61, the state submits as follows. On the charges of unlawful possession of firearms and joint possession principle, the High Court of this division has recently pronounced on same and convicted the accused on those charges based on the principles as indicated on Exhibit G. That being the case, Your Worship, at the back of our minds, we have got how the attack is crafted in the founding affidavit and the heads of argument. First of all, the issue of duplication of the charges, the splitting of the charges, in respect of the first 2 counts, conspiracy to commit murder and murder. I pause there. Your Worship, the greatest advantage we have is that this honorable court has been sitting in the court of first instance for years. invariably would have served the indictments on the accused who would have been transferred from the court of the first instance to the High Court in terms of Section 75, subsection 2. That being the case, this court would have observed the practice in the division of making those two counts, the main and the alternative count, not separate counts. So, if you look at the two decisions that the state has submitted, State versus Gabash, two accused were involved before the Honorable Acting Judge Hlachwayo. My learned colleague for the state, Mr. Gwega, was prosecuting conspiracy to commit murder, and then unlawful possession of firearm based on joint possession doctrine. The learned judge granted 174 in respect of accused number 2. And if you look, that will be in paragraph 17 of Gabash. So which means the matter proceeded beyond state's case in respect of accused number 1. Those two counts, and then at the end of the day, the learned judge Hlachwayo convicted on murder and possession of firearm and ammunition. Interesting in that case, the learned judge, Mr. Hlachwayo, stated that the state, my learned colleague, Mr. Gwega, was able to present evidence beyond reasonable doubt that accused number 1, that would be Mr. Gabash, is the one who was in physical possession of the firearm. However, the state failed to prove the second leg. So that submission, Your Worship, it addresses the conspiracy to commit murder and murder, as well as the issue of the joint possession of firearms. Your Worship, it is on that basis that in paragraph 30, a history has been given tracing the principle on the splitting in respect of those two counts. Paragraph 30 of my heads of argument. It is particularly paragraph 30.1, where I state the following. The diachronic approach makes it clear as a day that archaic is sacrosanct criminal law principle of splitting or duplication of charges. Accordingly, conspiracy to commit murder and murder, count numbers 1 and 2, constitute splitting or duplication of charges in this matter. The learned author, C.R. Snyman, in criminal law textbook, defines conspiracy as an inchoate, formally defined crime, whereas murder is a complete materially defined crime. Hence, more often than not, the rule of practice is that the former is an alternative to the latter. 30.2, however, the criminal law principle of splitting or duplication of charges, particularly in respect of conspiracy to commit murder and murder, has long been enunciated and put to rest by the Supreme Court of Appeal, first in R versus Min and Ailey, then State versus Fraser, and most recently in State versus Nongogo versus the State, in bracket, that would be in footnote number 31, the full citation, open bracket 852/2020, close bracket, open bracket 2021, ZASCA 166, paragraph 3. The application for leave to appeal was granted against conviction and sentence on conspiracy to commit murder and murder by Mjali in Nongongo. This case, Your Worship, it emanates from Umtata. And then on appeal, Nichols, J.A., Wilsaldaka, ADP, and Mochumi, and Mokotloa, and Govan, J.J.A., in the Supreme Court of Appeal concurred that the state had correctly considered that the applicant should have been convicted of either murder or conspiracy to commit murder, but not both. This is the Constitution, the SCA. This was explained in State versus Fraser. Normally, where a person conspires with another to commit a crime, and the crime in question is committed, then the conspirator is liable for the crime itself and should be so charged. A reference is made to Puchel. Then the charges continue. This concession is well made, and therefore, the appeal on duplication must succeed. And Your Worship, the second case of Lowe's, which I think is the most recent one, my learned colleague Zaba and Gwega again were prosecuting. In the case of Lowe's, Your Worship, it would appear that he convicted. He convicted on conspiracy to commit murder and convicted on joint possession, unlawful possession of a firearm and firearm. But my submission, Your Worship, is those two are now contradictions. Hlachwayo saying no, agreeing with the Supreme Court of Appeal, Lowe's convicting. My humble submission is that we go back to the basic principle of stare decisis, that we stand by the Nongo court decision to say at least the state does not have those two charges. There's doubt in respect of those two charges, conspiracy to commit murder and murder. The same with the joint possession of firearms. I have enunciated the principle, including the Makubela decision. If you look at the Kabasha decision, where my learned colleague Twega was prosecuting, understandably stemming from State versus Kosi, State versus Mbuli, with regard to a number of cases, including the Makeleni decision that I've cited, Your Worship. My humble submission is the principle has always been there must be proof which one had a physical possession of the firearm, and then a number of facts from which the trial court should infer. The one who had a firearm physically held it on behalf of the other accused. If you look at the Kabasha decision that the state has submitted, we are humbly submitting, Your Worship, that the applicants have succeeded in demonstrating how doubtful the existence of the two charges will continue during the trial proceedings. The same with the joint possession, Your Worship. Your Worship, the other, I won't go further, Your Worship, in respect of the joint possession. I've explained it in paragraph 30.5 in the interest of time. I was just explaining the principles, except that including the most recent decision of the Makeleni. Your Worship, then another aspect that I think the applicants have succeeded in doing, they've shown the doubt, conspiracy to commit murder and murder. They've shown the doubt in respect of the unlawful possession of firearms, ammunition, and the firearm, relying on the Kabasha decision and relying on the cases that I've submitted here in court, which does not necessarily require the presentation of the evidence. And then the interesting one, Your Worship, is the issue of the 803,000 rand deposited, which becomes the subject matter of of count numbers 11 and 12, i.e. the money laundering charges. Your Worship, with regard to that charge, my humble submission is, both in the state founding affidavits as well as in the heads of argument, there is no dispute, there is no serious material dispute how the applicants are demonstrating that for those charges to stand the test of time during the trial, required will be the 3 points, the ABC point. And the most difficult part, Your Worship, is with the A point in this matter, this court can't make any negative or adverse finding against the A point, the deposit. Is it Blue Cycle entity that deposited 803,000 rand into accused number 4's counts? The reason, Your Worship, maybe if I may read this paragraph in its entirety, 30.6, there is no dispute in respect of A, B, and C points averred as a vehicle or mechanism through which money laundering is determined by first applicant in his founding affidavit, in that to constitute the offense of money laundering, there ought to be point A as the original point of departure for the money, but requiring point B as a laundering, washing or cleaning up point, so that it reaches the destination point C, supposed to be C, appearing as innocent money. Gravely concerning is that the bank statements presented by fourth applicant and a letter on court record by the Gaba brothers that there are other payments made by the same entity into the bank account of the fourth applicant, but through the cherry-picking approach, the focus has been, the focus of and by the investigating officer was only on 803,000 rand. This has an effect of creating a smoke screen around the normal, legitimate deposit. At any rate, the law requires this honorable court not to make any adverse finding against the deposit, that is the Blue Circle entity. The making of adverse finding against the person not party to the proceedings, according to Hams DP in National Director of Public Prosecutions versus Zuma, open brackets in footnote number 37, 573/08, close bracket, open bracket, 2009, close bracket, ZACA, paragraph 1, paragraph 13, handed down on 12 January 2009. It amounts to changing the rules of the game as it takes the eyes off the ball with the effect of red carding not only players but also the spectators.
I accept and I respect that you are not representing applicant number 4, but how do we explain the fact that applicant number 4 in his papers does not attach the bank statement showing the transaction of the 800,000 deposit, and even when it is brought to his attention or to his legal representative attention that that part of the statement is lacking and is not part of the statement, he refuses. I say refuses because it was brought more than once to the attention of the council, and up to this date that portion of the statement has not been brought before court.
Your Worship, I fully agree with the court that if one were to look at that in vacuum, it concerns. But if one looks at it in the context of the fact that there is also a letter that is now in the public domain, confirm even in the bank statements that are before this court that other than these deposits, it would appear that that evidence has not been disputed.
Yeah, but is applicant number 4 playing open cards if he submits a bank statement, but this bank statement purposely omit the dates on which the 800,000 was deposited?
Your Worship, I take it that my learned colleague, Mr. Jorgensen, addressed the court on that aspect. Safe to say that in the light of the fact that the money laundering charge is also faced by the other applicants, particularly 1 and 5, the only submission I can make is that if one were to look at it in vacuum, it is a problem. But the moment the information comes to the fore that it's not only the deposit in that account, it neutralizes everything.
This was only, by the way, you are not in any event representing applicant number 4, but you mentioned applicant number 4's name, and that is why I'm raising this. This is the question that is going to be raised when the heads on behalf of applicant number 4 are presented, are made. But you have referred to applicant number 4, and that is why I'm raising this. There is a concern, and that concern has not been addressed. Even I had to say to Mr. Dwega, you cannot force applicant number 4 to supplement his papers if he's not prepared to do that. What is that?
As the court pleases, to the extent that money laundering is also has also been preferred against the other applicants, particularly 1 and 5, the only submission I make, Your Worship, is that it gets neutralized if the information comes to the fore, which is also in the public domain. Then it's not only the deposit in account number 4, there are other accounts. So which means those accounts, Your Worship, if there was a serious challenge of wanting to charge with money laundering, they ought to have been brought to the attention of the court.
Again, Mr. Mlocho, you are not representing applicant number 4. If you speak of other accounts, which other accounts are you talking about?
Your Worship, may I leave the point for my colleague on that aspect? Yes.
Better leave it for Mr. Jorgensen, because there are no other accounts that were submitted, and even the only account that we know of is wanting, to say the least.
But, Your Worship, the legal principle involved is that no negative adverse inference can be drawn against somebody who is not the...
question may be raised.
Yes, I fully agree with the court. I fully agree with the court. Your Worship, the other aspects, I think both parties have made submissions regarding the DPP's affidavit. Your Worship, with the DPP's affidavit, the way I've understood it, my learned colleagues for the state, their grave concern is non-compliance with Section 235, as well as the reason why it came about. In other words, why the director of this division had to depose to an affidavit. Your Worship, I cannot take the matter further other than stating that those points, the 8 points that I raised, the 8 points that are in the affidavit of accused number 1 and accused number 5 become relevant, with one addition, Your Worship. Your Worship, with one addition, when one looks at the principles of evidence, that would be Schwickert and van der Merwe on page 441, where the learned authors are saying the following. The topic is the Electronic Communications and Transactions Act 25 of 2002, the ECT Act. The two learned authors, I will quote just two paragraphs. The ECT Act moves beyond the concept of computer printouts and focuses on the term data and data messages. The Act defines data as electronic representation of information in any form. And then the second one is relevant here. The data messages as data generated, sent, received, or stored by electronic means and includes the voice, where the voice is used in automated transactions. So, Your Worship, which means the only additional submission I can make is that in terms of these learned authors, it becomes a computer-generated evidence by virtue of the fact that, among other things, it is not stored as a hard copy, but is stored electronically.
But what is the DPP's affidavit? What was it made for? What was its purpose in submitting it in the Eswatini court?
Your Worship, as I've indicated to the court, no intentions at all to regurgitate all the 8 grounds, except that my only submission is those 8 grounds, including the submission that I've made quoting from the learned authors, are the only submissions that I can make. I humbly submit, Your Worship, that both the submissions that the state has made and the submissions that we have made, they will be able to put this court in a position where this court can make an appropriate finding in that regard.
I want you to please assist me. What was the intention, what was the purpose of submitting an affidavit by Advocate Harrison in the Eswatini court? Why did she submit that affidavit?
Your Worship, it's common cause between the parties for provisional arrest.
To show that there is a case against the accused and they should be arrested. Am I understanding it correctly?
I fully agree with the court, Your Worship. But the problem is not only the alleged fugitive in Swaziland. It also explains the evidence against the accused that are before this honorable court.
To say there is a case for them to answer and they should be arrested or prosecuted.
That is correct.
Am I understanding correctly?
Yes, Your Worship. Yes, Your Worship.
Okay. And you have pointed out variances or differences between the affidavit by Advocate Harrison and Warrant Officer Pillay.
That is the position, Your Worship.
So, and the variances that are there, can you highlight them? I've seen 2.
Your Worship, other than the times, the issue of how evidence is presented by Pillay and the DPP. Particularly, let's look at accused number 1. Let me make an example with accused number 1. If one looks at the, if the court may bear with me, if the court may bear with me for a second. Your Worship, in fact, I intend addressing the court making reference to replying affidavit. That's the one that I'm trying to locate. We've got quite a number of voluminous documents. As court pleases, I am indebted to the court, Your Worship. Your Worship, with regard to the questions that the court has raised, those will, the amendments will be from paragraph 4.16, 4.17. That is the replying affidavit of the first applicant.
That is now Exhibit H.
That is correct, Your Worship.
So you are ready to form?
Your Worship, I was drawing the attention of the court to paragraph 4.16 on page 9.
Got it?
Paragraph 4.16 and paragraph 4.17, those are the differences in terms of time.
Just for the record, what are the differences in time?
As court. The affidavit was 4.16. The affidavit was deposed to by the Director of Public Prosecutions KwaZulu-Natal 2 days prior to the execution of arrest in Eswatini.
You have calculated time to say that, because my calculation was the difference in respect of the first one was 48 minutes, and the difference in respect of the second one was 8 minutes.
Yes.
Did I calculate correctly?
Correctly, Your Worship. And then
that is the difference. That is the variances you are referring to.
it's not the only variance, my
No,
Lord.
no. But yes, that is the variance you are referring to.
It is one, Your Worship.
But is this court seized with differences in the witness's testimony, or is that for the trial court?
Your Worship, again, in that respect, it's my humble submission that obviously there will be issues that this honorable court at the end of the day will indicate are for trial court. But in an attempt to discharge the honors, the accused has to present anything and everything. Hence, reference was made to Skitikat, how a broad approach is adopted. It is on that score, in the sense that in the world of law, there is no catalog list fixed saying this is what the applicant must present.
Yes, sorry to interrupt you. What is the duty of this court in the bail application? Am I understanding correctly? The question that needs to be answered by this court is there a case against the applicant? And if there is a case against the applicant, is there a risk if he is released on bail? Am I summarizing it correctly?
100% right. Will the accused stand trial if bail is granted? Will the interest of justice will the interest of justice best be served constitutionally and in terms of the jurisprudence? It's quite a wide variety of factors that is expected from the applicants so as to help this court to arrive at a decision where the court can say, I'm satisfied, the interest of justice warrant or the interest of justice does not warrant. And
this court should be wary of not usurping the powers or the duties of the trial court.
Yes, in fact, that is my main submission in paragraph number 1, that in Van Wyk, obviously, the court held in Van Wyk, 2005, volume 1, SACR 41, SCA, paragraph 6, that bail proceedings are not to be viewed as a full dress rehearsal for the criminal trial. I fully agree with the court, hence I have cited that case as an introductory
in the
remark.
application, for instance, there is inadmissible evidence that is admitted, like hearsay evidence, for instance. We admit hearsay evidence in bail applications, whereas in a trial court, hearsay evidence, you don't even mention hearsay evidence.
Your Worship,
Is it not so?
I do accept that hearsay evidence is admissible.
So, evidence that is inadmissible in a trial court may be admissible in a bail application, e.g. hearsay evidence.
Very true, Your Worship.
So why should we then go to the variances in Pilay's affidavit and Harrison's affidavit? Because that is for the trial court. Why should we not confine ourselves in whether or in the purpose for which these two affidavits are meant for? Harrison makes the affidavit to the Eswatini court for the Eswatini court to say there is prima facie evidence against these people you are appearing before you, arrest them. So is the affidavit by Pillay. There is prima facie evidence against these people. And Pillay has to go a step further and say that there are risks if they are granted bail. They may not stand trial. There are flight risks, etc., etc., etc. Am I following correctly?
Your Worship, the court has its finger firmly on the pulse. Your Worship, that is exactly what an attempt is made to do in paragraph 28, that the SCA has held that in Matebula, to 2010 volume 1 SACR 55, that the accused must on a balance of probabilities prove that the state case is non-existent or subject to doubt. It was in an eloquent and conscious effort to discharge that, to demonstrate to this court that as far as the applicants understand, if one were to show the doubt, among other things, let's look at the time. Let's look how the Inspector Pillay explains the evidence. Whether the court agrees or not, it's a different ballgame altogether. But at the end of the day, when based on our when given an opportunity, in terms of the legislature, to present evidence why exceptional circumstances exist, among other things, then that is present. And it's not the only aspect, Your Worship. That is why in the answer, in the replying affidavit, it was stated that hence the grounds were not proffered up front. They had to place reliance on Skitika just to give broad information why they are of the view that exceptional circumstances exist, which in the interest of justice or under release on bail.
Another aspect that I wanted to question. You are saying the state did not advance the grounds of opposing bail, and you cite Mr. Dlamini, yet there is no affidavit by Mr. Dlamini to say that that is indeed the fact. Correct?
Your Worship, there was no need for the affidavit.
But there is no affidavit.
There is no need because it's a submission that is part of this court record. It's common cause between the parties. Throughout, twice or thrice, the state was called upon to show reasons. The state saying, wait, in the modern era that we live in courts where this court is overburdened with bail applications and so on and so forth, at a pragmatic level, would not be an appropriate thing to do, to say 1, 2, 3, those are the reasons. Then as the bail proceeds, we are able to facilitate things.
Okay, let's proceed.
Yes. Your Worship, those are all my submissions, as I've already indicated that the heads of argument are before this honorable court, unless the court were to require me to clarify any of my submissions.
I think I will wait to you as we are proceeding. Forgive me for interrupting your train of thoughts, but I had to raise the questions as they emerged.
Your Worship, I came to this court well knowing I don't have luxury of leaving things unexplained. I understand that fully.
Thank you. So that is applicant 1 and maybe before you sit down, Mr. Mdodo, there is this one question that I need to ask, and I'm asking it now. So, in respect of applicant number 1, what are your submissions? What is exceptional about applicant number 1? Another question comes to my mind right now, which I'm going to ask after this one.
Your Worship, in paragraph 9, that is exactly what I was trying to capture, that though it was easy to enact, axiomatic and ineluctable from the judicial analysis of the South African bail jurisprudence is that the phrase itself, exceptional circumstances, is by no means easy to explain. It is again that background issue that I make reference to the State versus Jonas case and the number of cases that exceptional circumstances is not defined. There can be as many circumstances as the term in essence implies. The Constitutional Court in State versus Damini and others stated that in the final analysis, the evaluation is to do judicially, which means that one looks at the substance rather than the form. So it's against that background issue that I've cited quite a number of cases in an effort to help that. Your Worship, in the world of law, there is a great deal of unanimity that it causes headache to most of the lawyers in the world of law. The exact definition.
It is against that background that I'm asking, because what is exceptional in respect of applicant number 1 may not necessarily be exceptional in respect of applicant number 3 or 4 or 5. That's why my question to you is, what is your submission? What is exceptional in respect of applicant number 1? Let's confine ourselves at this point in time only on applicant number 1. We'll get to applicant number 5 that you are representing as well.
As the court pleases, the court may bear with me. Your Worship, though it has been put succinctly, I think the court will find the answer to the court's question in paragraph 7 and 8. In paragraph 7 and 8 of my heads of argument, in paragraph 7, I submit, it is accordingly humbly submitted that the applicant's main contention is that they have succeeded in discharging the onus resting on them to show and satisfy this honorable court that exceptional circumstances exist which in the interest of justice permit their release on bail. In paragraph 8, their personal circumstances. Your Worship, I was trying to be short without citing all the personal circumstances they've given in their founding affidavits. The reasons they have proffered for release on bail, all those reasons are in the affidavit, Your Worship. In the footnote, I make reference to that. They are undertaking to comply with any term and condition in terms of Section 62 of the Criminal Procedure Act, make out unequivocally a case that the applicants ought to be admitted to bail.
So that is your answer to my question.
I apologize, it's a long answer to a short question.
Thank you. Another thing that pertains to applicant number 1, which I say is the question that comes to my mind, which had slipped my mind, but because of the questions I've raised, it come to my mind again.
Yes, please.
There is a dent or allegations that were made against applicant number 1, and there is an affidavit to that effect by Dr. Moodley to say the wife of applicant number 1 was in his rooms, I think on the 11th of March, and she was with the applicant number 1, who presented to Dr. Moodley that he was an employee at Fosco, and Fosco is known to all of us who are coming from that area that it's full of dust, and he's suffering from sinus and things. In other words, the person of applicant number 1 was in the rooms of Dr. Naidu or of Dr. Moodley, according to his affidavit. And if you look at the list of patients that were in attendance in Dr. Moodley's rooms on the date in question, the name of applicant number 1 appears. Now, what is that?
Your Worship, I understand that is what my learned colleagues for the state are also raising in paragraph 7. Applicant 1 alleges that he has...
Unfortunately, I did not read there. I did not have time to read.
Yes,
I'm raising these questions from what I've read.
Yes,
I did not have the opportunity of reading the state's ahead.
As the court pleases. Your Worship, the state in paragraph 57 says applicant 1 alleges that he has a chronic asthmatic health condition. It is important we submit to note that in this regard, applicant 1 submitted in court a doctor's note from a Dr. Moodley. The state followed up this information and obtained an affidavit from Dr. Moodley. Reference is made to KP8 to Exhibit G As per KP8, it is clear we submit that applicant 1 handed false evidence in court during these proceedings. This we submit is one aspect that this honorable court should consider. Your Worship, my submission is the state has made reference to the case of State versus Yanta from the, I think it's from the Eastern Cape. I see there again that a medical certificate from a traditional healer was handed up. What distinguishes it from this case is that the learned magistrate and the parties agreed that the matter be postponed for the state to follow up. It turned out he did not consult with the traditional healer. But, Your Worship, with regard to accused number 1, in his replying affidavit, and it cannot be disputed, he is currently receiving chronic medication for his asthma. In his replying affidavit, he says he is receiving a pump. So, Your Worship, had the state confirmed with the Health Division of Westville Prison, that information would have been confirmed.
I'm trying to accept that applicant number 1 is asthmatic and he is receiving treatment for it. I don't have issues with that. I want to accept that. But what I'm questioning is the conduct. When he is in Westville Prison, he is appearing before Dr. Moodley. His name appears on the list of patients that were to be seen by Dr. Moodley. Before Dr. Moodley, he is pointed out, that is Mr. Mkwana's. And his name appears on the list. Now my question to you is, what is that?
Your Worship, my respectful submission to that will be two. One, probably miscommunication between the accused and the wife, because according to Mr. Pillay, it would appear that the person who was there was a pregnant wife. My instructions were, when he wanted to continue with treatment at Westville Hospital, they wanted a note from the doctor. That's the instruction that I was given. To exit the point, Your Worship, my humble submission will be, this court is a creature of statute. It can't do anything unless the law says it can. In other words, this court can make a credibility finding against applicant number 1, as that responsibility rests fully on the trial court as this court has earlier on indicated.
But this information that applicant number 1, when he was at Westville Prison, appeared before Dr. Moodley, what is it?
Your Worship,
because that is the impression created by the papers, and that is the impression which was given to Dr. Moodley. Dr. Moodley has since filed an affidavit to that effect, and he is referring to a person in front of him who was referred to as Lindo Buhle, but Mr. Mkwanazi.
as God pleases. Your Worship, in the light of the fact that neither the state nor the court, in terms of section 60 subsection 3, ordered that the medical records from Westville be brought to court, in the light of the fact that in the replying affidavit, applicant number 1 takes this court into full confidence, saying, my legal team has attempted to procure the medical records from Westville to present them in court. However, Westville Hospital says, without the order of the court, they can't release those medical records. Therefore, the fact still remains, which is the subject matter of the submission, that applicant number 1 is a chronic asthmatic patient receiving medication at Westville Prison.
You are not the witness, you are not an accused person, so it would be unfair to subject you to cross-questioning, and I don't intend doing that.
I fully understand.
And I'm not doing that.
I fully understand, Your Worship. I fully
But
understand.
the question still remains, was it not misrepresentation that was made to Dr. Moodley? That the person is Lindobuhle Mkhwanazi.
Whereas in truth and fact, it's not.
Whereas in truth and in fact, that person was not Mr. Mkhwanazi, because at that point in time, Mr. Mkhwanazi was in Westville Prison.
Your Worship, I fully, as an officer of the court, I fully concede that on that aspect, Your Worship, except that the only submission will be, because at the end of the court, this honorable court will have to make a finding: is he a chronic asthmatic patient? In the absence of the evidence from the state, and his declaration is replying affidavit that whoever challenges that I'm receiving asthmatic medication from Westville, if the order is obtained, based on the order of the court, that information can be presented. So that information still, that fact still remains, Your Worship. I am indebted to the court, Your Worship. Your Worship, one aspect, my apologies, one aspect being brought to my attention by my instructing attorney Dlamini is accused number 5 voluntarily handing himself over. That demeanor is not a demeanor of a person who is a flight risk. After the call through the mother had been received, he did a legal thing under the circumstances to get a lawyer, and the lawyer handed himself over to the police.
Ms. Gilling.
Ms. Gilling, who is in court. So the issue of flight risk, Your Worship, there is no objective, dependable evidence the state presented to substantiate that allegation.
In your submission, what is exceptional about him?
In the court within which,
The fact that he presented himself.
Your Worship, in the court within which this honorable court will be cooking that decision, whether or not exceptional circumstances exist, among other things, this honorable court will also consider the voluntary handing over to the police by the applicant.
Thank you.
As court pleases.
That concludes.
On behalf of 1 and number 5, Your Worship.
Number 2, are you in a position to argue now, Mr. Volmarans, or should we take a short break?
My learned friend is whispering to me that we should take a short break. But I'm ready. When the court is ready, I'm ready.
Did he whisper to say how long?
Your Worship,
Am I taking instructions?
Your Worship, we're in your hands.
I forgot my water. Can we resume at 12 o'clock?
Yes.
Please, let's resume at 12 o'clock. resumption after short adjournment. Thank you, Mr. Lawrence.
Thank you, Your Worship. Your Worship, I do not intend to regurgitate all the cases and authorities and the like that my learned friend for accused 105 have already dealt with. Just one or two points that I intend to deal with. I associate myself with...
Before we go, let's place on record that applicant two's heads of argument are accepted. I have got a hard copy thereof.
Yes.
And it's accepted into the record. It's marked Exhibit O.
Yes.
Thank you. You may proceed.
Thank you, Your Worship. Your Worship, as I've said, I associate myself with what my learned friend for accused 1 and 5 has said with regard to the various authorities that he has referred to. Your Worship referred to, in a question to my learned friend about the delays. What must be borne in mind is that applicant number 2 has been in custody since October last year.
Sorry, Council. Clarify yourself. Delays? What delays are you talking about?
Sorry.
What delays are you talking about? Let me
The
understand.
delays that Your Worship, well, it was first raised by my learned friend for accused number 1, and then you asked him about the delays. And I'm just saying, this bail application started in March.
Yes.
He's been in custody since October last year. And it's not as though he was unaware of this particular case. He was aware of it. And he was questioned about it at that time when he was arrested. So this is nothing new to him. And when he handed himself over through his attorney, then where does the flight risk come in?
Applicant 2.
Sorry, Your Worship.
Applicant 2 had himself over.
Yes. Sorry, Your Worship. He was arrested in Johannesburg.
Yes.
My apologies.
Yes.
But he's been aware of this case all along. That's the point.
But he was in custody on another case.
Yes. But he would have handed himself over had he been given the opportunity to do so.
But Mr. Volmarans, let's understand each other so that we will flow. Where does handing himself over come in when he was arrested in Maponya Mall and brought to KZN?
Your Worship, it doesn't come into it. What I'm saying is, if he was out on bail or out at the time that his co-accused, he would himself, because he's represented by the same attorney, had he been out and not in custody, he would have handed himself.
I think let's rather talk about what happened. Let's rather talk about what happened.
Yes.
Did he hand himself over? Was he arrested?
He was arrested in Johannesburg.
So handing himself over does not feature.
It doesn't enter, as Your Worship points out. Now, as has repeatedly been pointed out by my learned friend, the state has not taken the court into its confidence. And Your Worship raised the question about the investigation and how far it was and so on. And if I may quote from the state's heads of argument, which unfortunately you have not had the opportunity to read, but if you go to paragraph 62, the state further indicated on Exhibit G that there are further investigations that are still outstanding in this matter. It has been indicated that there is all likelihood that further persons may be added as accused in this matter pending the finalization of investigation. It is not a secret that certain evidence is being followed up, which means that the investigation is not complete. There can be no other interpretation to that. Therefore, to indicate that certain people should have been arrested at present is jumping the gun. The state never mentioned that the door of investigation has been totally closed. The contrary is actually true. So the state are conceding that the investigation is nowhere near complete, which means there is going to be delays. All right? There's been a delay since February last year when the deceased was shot. The extradition proceedings, and if there is a person who can talk with authority, it is my learned friend for accused number 1 and 5, because when he was part of the DPP's office, that was his function, was to deal with extraditions. And, Your Worship, I have no doubt that he is not going to contradict me if I say an extradition from one country to another, as close as what we are, can take up to 2 years, if not longer. So we're not looking at a trial which is likely to take place any time this year. Your Worship, I'm not going to deal with the bank statements, even though I handed in accused number 4's affidavit. My learned friend for accused number 4, applicant number 4, will deal with the bank statements. But there's a lot to be said about that. Your Worship, it is not sufficient in a bail application to say that there is a risk unless that risk is backed up by evidence. In other words, the authorities have said that there must be a likelihood that a particular result is going to result because there is evidence to support that. Bail should not be refused merely because the police say there is a risk. Now, as far as accused number, or applicant number 2 is concerned, there is no evidence to suggest that he is a flight risk. The mere, if I can use an example, if the state were able to produce an aeroplane ticket that was imminently to be used, then the state has reason to be concerned that he's going to be a flight risk. But merely to say he's a flight risk is not sufficient. Your Worship, the state has seen, and I can find nothing else in the state's heads of argument except which appears at paragraph 63 and 64, where the state deals specifically with applicant number 2. And it's on page 16.
Yes, I've got it.
Yeah.
Paragraph 63.
Now,
Dealing with the passport.
yes, dealing with the passport. Applicant 2 knowingly supplied false information in another bail application that he was not in possession of a passport. Now, if one goes to Exhibit L, at paragraph 3.5, he explains that. The position is, Your Worship, that when the accused was arrested, his passport was seized. It's not as though the police had to go look for it. They were in possession of it. Up until today, they are still in possession of it. So to make a big song and dance about him allegedly lying when he says, look, it's a genuine mistake. The drafter of my affidavit made a mistake. I didn't pick it up. Can't hold that against him. And what is more, Your Worship,
The drafter coming to confirm that I made a mistake. Me, Miss or Mr. Drafter made a mistake.
Your Worship, it's not required. He doesn't have to prove every single thing that he says. The state are aware of it. So what difference is it going to make if the drafter, who happens to be me, says, I made a mistake? Where's that going to take the court? It's not going to take the court anywhere.
But these are bold allegations made by the state that he
Precisely that, Your
he
Worship.
lied. And the response by the applicant is that it is Mr. Volmarans who made a mistake, the drafter. The state is aware, but is the court aware?
Well, that's what I'm saying, Your Worship. The court is now aware because he's put an affidavit up to say it was a mistake. It wasn't deliberately done. It was never deliberately done. But in any event, Your Worship, I submit that the state was wrong in putting up that affidavit, in fact, putting up those, that bail application. All right? And the reason why I say that, I've dealt with it extensively in my head, Your Worship, but as well, if you read section 60, where it deals with the record of bail proceedings, and I'm quoting now from the Act, the record of bail proceedings, excluding the information in paragraph A, which is for previous convictions and pending cases, shall form part of the record of the trial of the accused, following upon such bail proceedings. It does not say any proceedings. So those bail is not criminal proceedings. So the state were not entitled to use that because it is only admissible at trial, not any other time. And, Your Worship, as I say, I've dealt with it extensively in my heads. Now, paragraph 62, or rather 63 and 64 of the state's heads of argument are the only thing that they can point their fingers at the accused as having, let's say, done something wrong. He hasn't done anything wrong. It does not say subsequent proceedings. It just says trial proceedings. So they were wrong in using it.
But could it not have been misleading to someone who is not informed?
Sorry, Your Worship, I don't
Could
know.
it not be misleading to someone who is not informed, like the state, which is informed that the accused has the passport because it was seized upon arrest? To someone like me, who does not have such information, could that not be misleading?
Your Worship, not when it's explained.
So it is until it is explained.
Yes, it's been explained. In Exhibit G, they make this allegation. In Exhibit L, it's explained. The state have been aware of it all the time. They can't say we were not aware of the fact that the accused had a passport. They can't say that. They were aware of it. They were in possession of it. So, Your Worship, that statement was not designed to try and mislead the court. That's why there's an explanation. Drafter of my affidavit made a mistake. What more would the person listening to the affidavit expect? Your Worship, other than the submissions already made, unless Your Worship has particular questions, those are my submissions, that the accused or the applicant has discharged the onus. He has his personal circumstances, the fact that he's been in custody all this time, the fact that he is productively employed, that he contributes to the fiscus, that he has a family to maintain, I submit are all relevant, and when put into the melting pot for the court to decide whether or not those amount to exceptional circumstances, I submit they do. There are exceptional circumstances. He has more than one wife. He has a number of children that he has to maintain. So, Your Worship, by keeping him in custody, all we're doing is making his children suffer. And, Your Worship, one must bear in mind the business that he is involved in, namely the taxi business. That's cash business. He can't collect his income. And that income, those people who are employed by the applicant are not going to go to his wife and say, your husband is in custody, so here the day is taken. It doesn't work like that. So his family are suffering as a result of him being in custody. And I submit that is a very serious consideration when it comes to bail. Unless Your Worship has...
Well, we have touched upon it, and I want to take you back to it. His business is in the taxi industry.
Yes.
By his own statement under oath, his family is involved in Malugazi faction. Yes. And some of his family members have been killed. Yes. Through the violence that is there, because that industry is volatile, particularly at Malugazi.
Yes, sir.
The risk that is there, if he goes out, that he may also be eliminated.
Your Worship, as you've said, he wasn't arrested at Malagasy. He was arrested in Johannesburg. So he's kind of divorced himself away from where the violence is. He's still running his business, but he's not living in Malagasy where violence is taking place. He feels he is safe, because otherwise he wouldn't be bringing this bail application. He'd probably say, well, I'd be safer in custody.
But objectively speaking, is he safe?
Objectively speaking, yes, because the other members of his family may have been eliminated. Other taxi bosses. This is something that happens every day, not just here in KZN,
Yeah.
in all the provinces.
Yes.
But it doesn't mean that his life is under threat.
Is
His
it not?
life hasn't been threatened so far. As far as we know, we have no instructions to the contrary that his life has been threatened. So until there is a threat, an actual threat, not a speculation, then it's neither here nor there. Worship, I'm also advised that there has been government intervention as far as the taxi violence in KZN is concerned, which has resulted in a great decline of taxi violence in the KZN. I can't give you worship percentages, but so obviously the state are doing something right.
I'm raising this because it's contained in his own statement that the situation is volatile, and he cites particularly Maluga's rank, that there is that faction over who is to manage Maluga's rank. It's in his own statement. That's why I'm taking it.
I agree with your worship that that's what is contained in the statement, but he's not there. And he's not part of the faction that is trying to fight for who is responsible or who takes over the taxi rate. He has people working for him. And in any event, Your Worship, as was stated in his affidavit, any I'm loath to use the word likelihood because the state uses the word interchangeably with likelihood and possibility. But any such likelihood, and one has just to refer to the Eastern Cape case, any likelihood can be overcome by the imposition of conditions. So if the court said, right, I'm releasing you on bail, but you may not go back to Malagasy. If he then goes back there, he's broken the bail condition, he can be arrested. All the state has to do is apply for a warrant for his arrest and he gets arrested.
I think let's do justice to applicant number 2. Let's be fair to him. Let's give him a hearing. Allegations have been made by the state that applicant number 2 is part of the group. He received 133,000 rand from applicant number 4. Don't you want to address the court on that?
Well, Your Worship, yes, he did receive a sum of money for services rendered. That's what he says.
But that's exactly what I'm saying. Don't you want to address the court on that so that it is on record that you have touched on that as well? That's why I'm saying let's do justice to him.
Well, Your Worship, I believe we have touched on it. We've said the money we received is for services rendered. What more do we have to say, Your Worship?
No, it's not for me to answer. I was just bringing to your attention that
Yes,
are you
Your
not
Worship, and
omitting,
that's
are you
it.
not omitting that one aspect? Because
No,
it's
I
allegations
don't-
made against him.
I don't believe so, Your Worship,
Okay.
because I believe that by saying I received money for services rendered, he denies that he was involved in any nefarious activities of murdering the deceased and his compatriot. He denies that. He says, I will plead not guilty.
You see, I'm raising this so that there are no aspects of evidence that are left not addressed. That's why I'm raising this up.
Well, Your Worship, the services rendered are also explained by applicant 4. He says, yes, I received money. I distributed certain monies for services rendered. What more must he say? I'm sorry, Your Worship, I'm not questioning the court, but I'm saying.
But exactly, it's not for me to answer those questions.
No,
but it's for him to say, there is this piece of evidence that has been tendered, and there is that piece of evidence that has been tendered, and that piece of evidence, my explanation is grant me bail because of my explanation.
Your Worship, and I believe that I've addressed that. Grant me bail because, yes, I received money, but it was for services rendered, not for any unlawful purpose. Unless there are any other issues, Your Worship, those are my submissions.
Well, I've drawn your attention to certain aspects. I cannot draw your attention to all the aspects. Then, as I was saying, let's do justice to each and every one of the 5 applicants so that we give them a fair hearing, that whatever has been said on their behalf is answered and is addressed. If you are satisfied as his counsel that you have addressed everything, I'm not going to poke you and say that.
Well,
Wait
Your Worship, I do believe that the relevant issues have been addressed in my heads of argument and also properly answered in the affidavits. So if there's some aspect of my heads of argument which Your Worship is unhappy about, I'm happy to address that.
It's not that I'm not happy about.
Well, Your Worship, I use the word loosely.
Mine is to address my conscience and make sure that at the end of the day I've been presented with all facts and all facts have been properly addressed. Not because I'm not happy about anything, but
Worship,
I want to do justice to everyone.
Your Worship, I use the word unhappy loosely. I'm not saying you are unhappy. I'm saying if Your Worship has concerns, I'm happy to answer those concerns.
Anything else, Council?
Those are my submissions. Thank you.
Ms. Gilling?
And the court pleases Your Worship, the heads of argument for the applicant has been filed with court, Your Worship, if that may be marked as an exhibit.
Exhibit P.
Exhibit P, as the court pleases Your Worship. Your Worship, the Exhibit C is the founding affidavits of applicant 3. The replying affidavit to the state's opposition is Exhibit J. We stand by the content of those affidavits. We feel we've addressed what needed to have been addressed. The heads of argument have been filed. We feel that everything that needed to be addressed and highlighted in respect of the evidence had been addressed in the heads of argument. In respect of applicant 3, it is poignant to note that the evidence that was led is contained in numerous affidavits, Your Worship. The affidavits are incapable of being interrogated because nobody's being cross-examined. So in this respect, the submissions made in the affidavits are the submissions that stand before court. Court is now going to have to interrogate the truth or, I suppose, deception in these affidavits. Your Worship is left with a whole lot of truths. And there's none of the persons that had filed the affidavit that stand before court and say, I am lying through my teeth in respect of this. But anyway, so Tuesday I was here. Everybody is submitting whatever they've submitted in the affidavits as truth and as fact, Your Worship. So that is before court. That will be up to the court to decide, Your Worship. The heads of argument, in my view, that I filed on behalf of my client, addresses, in short, points that I had highlighted in my affidavit, Your Worship. There will be no further submissions. I have read the heads of argument of the states, and I have no further submissions in respect to the states' heads of arguments, Your Worship.
As a reminder, by the way, how many charges, or how many charges is he facing other than this one?
How many matters?
How many matters is?
Your Worship, there are 4 matters. The one is in Chatsworth.
4 matters, just tabulate them.
I will do. The first
4.
one is in respect of firearm possession, and that is now in Chatsworth. It's actually an Umlazi matter, Umlazi Regional Court matter, but the court is sitting at Chatsworth Regional Court because of the facilities.
Possession of firearm.
Yes.
2.
Then there is a second matter that my client is on bail for in DC 10. that will be for possession. I think there's a myriad of charges in respect of a shooting incident in which a person passed away. It's alleged to be a taxi-related incident, Your Worship.
But what is the charge?
So it would be murder, attempted murder, possession of firearm. I think in that one there might be an allegation. No, I think that's as far as that is. Then there is
That is two.
that is two. The third one is the matter in DC 11. We're nearly finished with the bail application. We're ready to file ahead, Your Worship. That is in respect of murder, attempted murder, possession. Also MI2P in respect of holes in the vehicles that sustained the gunshots. Not money laundering or anything to that effect, an attempted murder, and also failing to assist a pedestrian that was injured. So it is also in relation to a shooting incident. It's a murder matter, and conspiracy that is now in DC 11, Your Worship.
That is 3. 4,
This is the one that we're dealing with here, Your Worship.
which is murder. among
Which is
others.
murder as well, yes, Your Worship.
Now, the question that comes to mind is propensity
Your Worship,
or alleged propensity.
yes, Your Worship, in this regard, we're sitting with an applicant that has no previous convictions, no pending cases. At his age, he walks in, the first matter he is arrested for, all linked to all these matters. This is the Umlazi matter last year, April, Your Worship. At that time, and this is where my client's position comes into play at this point in time, having 4 matters against him. At the time, and it is so in my affidavit, the investigating officer says, clearly, during the bail proceedings, it is the firearm that's linked to these 7 offences, and that is why he's opposing. And he lists the 7 incidents of murder. And the magistrate had said, so the applicant is linked to these 7 cases of murder, and Mr. Parbu then corrects her and said, no, Your Worship, the firearm.
Yeah, but the question is still standing.
Propensity.
Propensity to be linked with violent crime where there is a loss of life.
Yes, Your Worship, but that is where I'm saying that my client was then subsequently piecemeal arrested on all the other cases in that affidavit, where he was not linked to it. This is a roundup of usual suspects, Your Worship. There is nothing at this point in time that links my client to any of these matters. He's on bail on 2 of these matters.
Ms. Gilling, how can you say that? Are you in possession of the statements?
I'm not in
the content of the docket?
I'm not in possession of
So
it, Your
how
Worship.
can you say there is nothing that links your client if you are not in possession of the content of the document?
We've dealt with the state's submissions on what they have against my client. And as much as the state can say they have a firearm that links my client, the state is, the defense is disputing that because we've addressed that firearm. And we said that firearm is not linked to this matter. And that firearm is not linked to my client. It was just that 7 persons were not in a home, not on a homestead, in a building at a tavern, arrested for those initial 2 firearms. 1, I don't know where that gentleman has gone to. 5 were released, 2 were then charged. And then they're saying my client is now linked with the firearm, with all the offences that is alleged to belong to the firearm. It is not so that it could say that my client has a propensity to commit crimes when all that is before court now is allegations that he's linked to a firearm that is linked to offences. That is all that's before court. It doesn't show that my client is a habitual criminal or there is a violent man, Your Worship.
I'm not in a position to say that he is a habitual criminal. But the question that comes to my mind is a person who is alleged to be involved in 4 matters that are violent related, where there has been a loss of life, is the conclusion, prima facie, that he has a propensity of committing violent offences or to be linked with violent offences escapable?
No, Your Worship, I would differ. I would say, had there been previous convictions, yes, then one would say you can conclude that the person might be a person that has a propensity to commit these crimes, but there's no convictions we're speaking of here. These matters, the evidence is not tested yet.
So all these 4 matters are
Yes.
before courts.
And it all happened within 1 year. The arrests. Yes, Your Worship, that's
But they
correct.
are all before courts.
They are all before court, Your
And
Worship.
in all 4, he is an accused person.
That is correct, Your Worship.
And you say propensity does not apply.
It cannot possibly apply because he's not been convicted. To be arrested for an offence does not equate being suspected of being the person that committed it unless...
The word in this context, propensity, is used in what context? Is it propensity to be convicted of offences, or is it propensity to commit crimes?
What the question would be, what points towards a propensity to commit offences?
To commit offences.
Yes.
Not to be convicted of offences.
Yes, but what points to the propensity to commit offences is the amount of times that you have been convicted, found guilty of them, not the amount of times you've been rounded up with a whole bunch of people as a suspect.
Why are we saying propensity to commit? Why are we not saying propensity to be convicted?
Propensity to commit could never be deduced or presumed from arrest, Your Worship. It has to come from something factual. It has to come from convictions.
See, I'm not arguing the case for the state. I'm raising this question for my own benefit because at the end of the day, I'm the one who has to give judgment. And
I
say,
understand. That's correct.
There is or there is not. I don't know where the state is going to raise this point, but I'm raising it as an officer of the court. Here you are, 4 matters against you. Are we not having here a case of a propensity to commit offences? Then I'm expecting you to address me on that. Is there no propensity, or there is propensity?
There could be no propensity unless the state is bringing something to the table that shows my client had committed these offences, and there can't be a presumed propensity, Your Worship. Especially not in these circumstances. There are various cases that's coming in and out of this court and the courts around us that are now, and it's been televised, that are now linked with one another. The Chatsworth case is now said to have gone to, it's adjourned to 10 June to maybe be consolidated with this one. So, or another one. So at this point in time, the state is grappling, maybe, and the one in DC-10, for which my client is on our bail as well, my learned friend had also indicated that is being adjourned to be consolidated with these other matters. So ultimately, perhaps a mistake was made affecting different arrests for various leads, making it appear as if there are 4, 5, 6 different cases, different persons for each case, where it should have been one arrest in one case. That's the only reason I can prefer to court of why my client is now sitting with 4 pending matters, because I've already been told DC-10's murder matter is going to be consolidated with this matter. Chatsworth matter is going to be consolidated with this matter. So then in that instance, it is not applicable now, but that then falls away, and it's just all one matter. So in essence, I can't say, unless my client is convicted or carries previous convictions, the presumption or the presumption of propensity cannot be said to be applicable here if there's arrests. Arrests are not going to point to guilt in this matter. They are confusing the matters as well, Your Worship. I get confused when I sit in DC-10 and my learned friend said to me, we're consolidating this one with the other matter. I'm saying, on what basis? And they won't disclose the basis either, Your Worship.
We can argue about this in the chain comes earlier.
That is correct, Your
But
Worship.
the question that comes in
That
goes
was-
down is it propensity to commit offences, or is it propensity to be convicted of offences?
Yeah, neither, Your Worship. There's no propensity to commit offences. There's nothing before court.
Is it propensity to be convicted of offences?
It's a propensity to be, in essence, my client's dad was a taxi owner, and he passed away. So I think it's a propensity to be rounded up as the usual suspect when taxi violence happens, and not all of them, and actually quite a few, do not land up at trial, Your Worship. More often than not, charges are both drawn against half, more are added. So I would rather say it's propensity to be rounded up as the usual suspects when there's violence in that area. But it's not a propensity to commit offences, Your Worship.
And I read your found an affidavit some time ago. I did not have time to revisit it again lately. Exhibit
C, Your Worship. Yes.
Am I understanding you to say that there is the state case against your client is weak?
That
He's
is correct,
also
Your
going to be applying for discharge in terms of Section 174?
No, most certainly not a submission in my papers that my client will be asking for a discharge in terms of Section 174, but during trial. But my submission is it's weak, it's exceptionally weak, and there are further considerations in my founding affidavit saying that the High Court has already considered this matter. It saw the affidavit of Mr. Padu. It saw the record. It knows about this. My client has been released on bail on 7 matters. On the founding affidavit, there's the High Court order. Attached to that is the record. The exhibits is my client's affidavit, the founding affidavit of the investigating officer, and that founding affidavit clearly says there's 7 other cases, and the High Court yet still granted my client bail on appeal.
That's not where I'm going. Where I'm going is, am I understanding you to say that there is a weak state case against your client when he is alleged to have been found in possession of a murder weapon a few months after the murder was committed?
Yes, Your Worship. It is most certainly my submission. The submission in respect of that is, firstly, if you have a firearm that's alleged to be linked to 7 or 5 offences, say around the coast, these firearms might, or this firearm might have been in possession of another person at another time. So it's not to say that if this firearm, that's why Mr. Padu had corrected the magistrate and said, no, it's a firearm that's connected to these offences. He didn't want to commit to say it's my client. My client was found in possession of the firearm, allegedly so. That firearm is now linked to this matter. And I've already addressed that in my affidavit, saying it's not the same firearm. The state has already said the second firearm in this matter has not been recovered. And as there's an argument that says the one firearm is sitting with the Chatsworth matter and the other firearm my client is charged with. It is incorrect, Your Worship. So, no, I would say...
That is why I'm raising this, because you are saying your client will be discharged in terms of Section 174. Will he not be called upon to come and explain his possession of the firearm? That is, if it is proven that he was found in possession of the firearm, because that is what the state is alleging. Does 174 feature here when he is found in possession of a murder weapon and he does not have to explain his possession?
Your Worship, in essence, maybe a Section 174 discharge, that's upon that minimum evidence upon which a reasonable court could convict and put him on the back foot in case he incriminates himself. Your Worship, then if he's not granted a 174 application, then he most likely would be in a good place to close his case and then have the state...
But you say in your founding affidavit, I will ask and I will be granted 174 discharge.
I did not say that in my founding affidavit, Your Worship. I think
it
was another one. It was for another applicant, Your Worship.
Okay. So
are you
prepared to concede that he may have to explain his possession? Because it's not in all murder cases where a murder weapon is recovered and found.
That is correct, Your Worship.
So if you are found in possession of a murder weapon, you need to explain your possession. And the doctrine of recent possession also come into play, is it not so?
Yes, that would be correct. But I was not the person, and my client was not the person that alleged. I think it was my learned friend, Mr. Nglocha's affidavit that said that he will be granted a discharge. I did not allege that in my affidavit. But while the court had asked me that, I had said, I was sort of caught off guard, Your Worship. That was one of my submissions, my client's submissions. Any further questions from the court?
No. Anything further you wish to say?
Nothing further, thank you.
You're not an accused, you're not a witness. I'm just asking you to assist me clarify some points.
So, thank you, Worship. The court had no sweating bullets now. No further submissions. Thank you, Worship.
Mr. Ferguson, it's 10 to 1. Will you be done in 10 minutes?
Excuse me, I may be done in 10 minutes, but your worship may not be done with me in 10 minutes.
Clarifying some of the things that I've seen you jotting down already, the points that came out during the submissions by Mr. Mlodjo.
Very well,
So,
sir.
will this not therefore be an opportune time to adjourn for lunch break and maybe take a shorter lunch and come back earlier so that you will not be interrupted and I will not be interrupted as well?
I'm completely in your worship's hands. It's your worship's hands.
With the permission of everyone involved, I propose that we adjourn for lunch now so that we start at 2 o'clock and continue because Mr. Jefferson is the last person on the applicant's side and then we can hear the state's case. That will also afford me the opportunity to look at the state's case so that I can also engage them.
3/2156 of 2024. The matter of the state versus Lindo Ushe, Tamani Kanazi, and 4 others.
Thank you, Mr. Jason.
As Your Worship, please. Your Worship, may I ask first, as a matter of housekeeping, that Your Worship accept the heads of argument on behalf of applicant number 4. I'm told it will be Exhibit Q.
Heads of arguments on behalf of applicant number 4, not P, but Q.
As Your Worship pleases.
So, applicant 3's heads of argument were accepted as Exhibit P. Applicant 4's heads of argument are accepted and recorded as Exhibit Q. Thank you.
As Your Worship pleases. So, Your Worship, I intended in my address to deal with applicant number 4's application for bail under 2 headings. For 1, exceptional circumstances, as in circumstances peculiar to him. And the second, and my submission is that exceptional circumstances must also be looked at in conjunction with the state's case. But I'm going to depart from that. And I'm going to address Your Worship's concern, well, I presume one of them, that Your Worship raised with my learned friend for applicant number 1, the bank statements. Now,
It's not only that. I was raising that to Advocate Lodge because he touched on it.
yes,
As far as I'm concerned, there's more than that when it comes to applicant number 4.
yes.
But I will address that as we proceed.
Yes.
You may proceed.
Thank you. So to deal with the bank statements, Your Worship, the simple reason why not all bank statements are attached is that applicant number 4 simply did not see a need for it, didn't see the importance thereof.
Now, how can that be when the talk of the day and the talk of the century is the 800,000 amount that was deposited? And why exclude or omit that amount when it is the subject matter?
For the simple reason that it's not disputed. So it's not disputed he received 800,000 rand. It's not disputed that he paid out sums of money. It's not disputed. Now, Your Worship should be aware that for the state to say, oh, we don't know his bank statements, that's an untruth. I'll tell Your Worship why. If Your Worship considers Annexure KP1 to the state's affidavit, Your Worship will note it's a collation drawn up presumably by the investigating officer. Now, he could only but have drawn up that collation if he had access to the applicant's bank statements and bank accounts. That's the first point. The second point is easy to subpoena them, and he could have done so. But, Your Worship, it's rather disingenuous of the state to say,
This is the applicant's case. He is the applicant in this matter. He is presenting circumstances and facts which support his application. Why should you, in your application, rely on someone else's information when you are in a position to present that information yourself?
we don't. We're not relying upon it. The 800,000 rand is common cause, and we see no reason to take that any further. He says in his affidavit, I paid the money, received the monies for business purposes, and I paid it out. Let's not forget the beauty of it, for the applicant going first, is that the respondent gets to investigate it. There was a good deal of time between the applicant's affidavit and that of the respondent. So they could go and investigate it. But Your Worship sees nothing dramatically to the contrary to what the applicant says in his affidavits. So, Your Worship, my submission is that really disposes of the issue of the bank statements. But can I take this further? So, Your Worship, exceptional circumstances. It's a question that is much easier to ask than to answer. And I'm sure when Your Worship interrogates the state, you will ask the state, well, what do you think exceptional circumstances are? What are exceptional circumstances? There are a multitude of cases dealing with exceptional circumstances and a person's personal circumstances. But my submission is one thing is for sure. It could not have ever been the intention of the legislature that exceptional circumstances are the exclusive territory of circus acrobats and double amputees, because hardly anyone would get that. Your Worship just needs to take cognizance of S versus DV. It's referred to in my head. Just to quote one line. Your Worship, it is page 5, paragraph 23.
Page 5.
Paragraph 23, Your Worship.
Page 5 is paragraph 12 to 14.
My heads of argument, Your Worship, is page 5, paragraph 23. Indebted to my learned friend, it seems that some of us have pages that one bit differently. I can't really explain it, but page 8.
Page 8.
Page 8.
That is where paragraph 23 is.
I beg your pardon?
That is where paragraph 23 is, on
Thank
page
you.
8.
Thank you, Your Worship. So if Your Worship looks at the second paragraph of the quotation from S versus DV, it would be futile to attempt to provide a list of possibilities which will constitute such exceptional circumstances. To incarcerate an innocent person for an offence which he did not commit could also be viewed as exceptional. So that then, Your Worship, takes me to applicant number 4's personal circumstance. Let's start with his arrest. The police raided his house. He wasn't there. Contact was made with his attorney. He surrendered himself the next day. He was supposed to have been at the police station 9 a.m. He arrived in the afternoon. Not the actions of someone who wants to run away and evade arrest. That also would not have been in the mind of the police, because I recall from the states found in affidavit that his home was under surveillance, and I think somewhere in that affidavit they say one of the team even spoke to him. Now, if he was a flight risk and he was going to run away, one must wonder why that member of the team didn't arrest him then and there. But be that as it may, he surrendered himself to the police. So now let's look at his personal circumstances. He has 2 wives, living in 2 different residences. One residence is rented, and he himself lives in the house with, let's call her his first wife, the doctor, and that house is the subject of a bond in the wife's name. So my submission is, he has a permanent address, no indication of him living elsewhere, and then he's got business interests that derive his income. He has children who attend local schools. My submission is that he is grounded in the area of jurisdiction of this court. Now we look at the offence. The problem is, Your Worship, in a bad application, as Your Worship knows, we're not entitled to the statements in the docket. We have to rely on the candour and transparency of the investigating officer. So let's analyze what he says in respect of accused applicant number 4. But bearing in mind, as your worship said, this is not the trial court. So we don't have to answer each and every contradiction, each and every little thing, because as your worship said, it's not the trial court. However, let's deal with the 800,000 rand. Common cause, he received the 800,000 rand. He informed the court via his affidavit where he got it from.
Affidavit.
Why does your worship say that?
Because the source, safe to say that from a reputable company, it does not state who the company is.
Very well, your worship. Let's not forget that the state had the ability to follow the trail of the money. And in fact, they did.
But again, he is the applicant. He is supplying the information.
Yes, your worship.
For that information
Correct.
to assist his application.
Except in this instance, it is perfected by the state's investigation. So the state has unwittingly corroborated what he's had to say. He said that he got it from a reputable company. The state has then informed the court that the payor was Mfundu Gaba through one of his companies. Now, the last time I looked, if you pay, as the state has alleged, for a hit, you are as equally guilty as the person who receives the payment for the hit. But the payor is not amongst these accused. It was raised on the last occasion, still not arrested. Why could that be? The state categorically said number 4 was paid 800,000 rand for a hit. They know who paid the money, but he's not arrested. The only conceivable reason why, bearing in mind everyone is equal before the law, is that there is no evidence to back up that claim that he was paid 800,000 rand for the hit. There's no other explanation for it. By virtue of the fact that the police do not arrest the payor, in fact the payor releases a press release that confirms what applicant number 4 says. Now that then does away with or weakens the state's assertion in respect of the 800,000 rand. So now all we have is applicant number 4 receiving 800,000 rand in the course of business. He says it's in the course of business. The state investigates. They can't find anything to suggest it's not. The only complaint is, well, how do we know he got value for it? No indication of value. Now, the simple fact of the matter is, as your worship sits here, and your worship knows, having been on the bench many times, the state doesn't have an automatic, a more beneficial route for the court to believe than an applicant does. Both sides are equal before your worship, notwithstanding the applicant has their own. It's a charge and the balance of probabilities. So that deals with the money. Now we can interrogate that all we want, but as your worship has said, this isn't the trial. The second factors are the motor vehicles and the cell phone. Now, what the state does is they only present a small fraction to the court. And they say he hired the Polo, he hired the BMW for purposes of the hit. Not so. Vehicles were hired before that. And before he changed to those vehicles, other vehicles were hired. But that is not put before your worship. And in fact, it's not significantly gainsaid either. So that explains really the motor vehicles. Then the remaining issue, to break it down, is the cell phone. And they say the cell phone puts him in the vicinity. But they don't tell your worship what the vicinity means. They don't tell your worship what the range of the vicinity is. As we are here in this court, could it extend as far as North Beach? Could it extend to the entrance of the court? Could it extend to the door of this court? You aren't told, sir. State does not take the court into its confidence. So, what do we have? We have 800,000 rand, and the businessman says, I paid him the 800,000 rand for business purposes. And that businessman is not arrested. We don't have a shooter amongst them. We have an extradition process in another country where they are trying to bring back two accused and to link them. And with all due respect, the NGA doesn't have a good record with extradition. So where does that leave this case? My submission to your worship is the following. One of the criteria, and I do not hang my hat solely on this criteria, but one of the criteria is if you can demonstrate on the balance of probabilities that you would be acquitted. And I would submit to your worship, if this is the evidence, and your worship is confined to this evidence, not what might happen, this bail application and your worship's ruling is confined by a snapshot in time. And that's the evidence that we have now that both sides have put before your worship. And on this evidence, I would submit accused 4 will not be convicted. Whether he's put on his defense or not, well, that's another discussion. 174 closing the case, be that as it may. But as I've said to your worship, I do not hang my hat solely on that. My understanding of exceptional circumstances are you can take particulars that are particular to the applicant, and you can look at that in conjunction with the evidence against him. And when you put both of these in the basket, so to speak, it allows a court to make a determination on exceptional circumstances. And it doesn't have to be specifically restricted to either the state case or the applicant's case. So, Your Worship, in a nutshell, those are my submissions. But once again, as Your Worship has said, this isn't the trial. So, Your Worship, subject to my reply to my learned friend, and of course, subject to Your Worship has indicated many concerns, that is my address.
There's a clarification.
Yes.
Or other concerns, not
Yes.
questions, because you are not a witness, you are not an accused. But please assist me, because I've got these concerns.
Yes, Your Worship.
In his founding affidavit, applicant 4, paragraph 47, if I'm not mistaken. Yes, paragraph 47.
Second, with Your Worship.
Yes, and if one reads that together with all right, let's start with paragraph 47. In paragraph 47, he states that he has a security for himself and for his family.
Yes.
He was at some point in time seriously attacked. Is he safe?
Yes, Your Worship. There is no indication that he's not. He simply explains.
Or security?
He simply explains what happened to him in the past and how he came to use the services of other individuals. The state does not say any degree of certainty that he is unsafe. And the simple say-so of an investigating officer without it being backed up by evidence in respect of anything. Yes, Your Worship. He explains. He says some time ago. And that was on a visit to the mine which is in, I think it's in Mpumalanga, Your Worship.
Because standing trial does not only mean flee, but it means not being eliminated whilst you are out.
Correct, so that the interests of justice can be fulfilled.
Yes.
Yes.
So that is why I'm asking myself this
I
question.
understand,
That's why I have this concern.
Yes.
Is he safe if he's outside?
So let me allay Your Worship's concern. Yes, he is. As he said, it was some time ago and it was on a trip to the mine. Let us not lose sight with respect, Your Worship, that the court is always open to or can impose conditions. And the court is able to eliminate any concern that it may have, or the state, by the imposition of conditions. And if, for example, the court is concerned that if he visits the mine, his life may be in danger, we don't want him killed, want the trial to reach an end, Your Worship is free to impose such a condition.
Paragraph 57 of his affidavit. I wish to be clear, I do not recall being driving, I suppose he wanted to say, I do not recall driving BMW,
Yes.
nor was I driving it on the day that the deceased were killed as alleged.
Yes,
What is he saying?
exactly that, Your Worship.
I do not recall.
He's saying, I don't remember driving a BMW.
I deny driving a BMW.
Yes, he says, I wasn't driving it on the day that the deceased was killed either. But now, of course, the question is, Your Worship, as Your Worship has mentioned, how far do we interrogate the evidence? And this is not the trial. This is bail.
Well, it's relevant to ask this question in light of the allegations. He does not say in no uncertain terms, I deny driving. I do not recall. There is a difference, if I understand correctly. I deny driving the BMW on the day in question,
Yes.
as opposed to I do not recall. I do not recall driving the BMW.
Well, then,
Is there a difference or not?
If Your Worship will allow me to break it down.
Yes.
The day that the deceased is killed, that's a day that generally an individual will recall more readily than an ordinary day some time ago when asked later on, what did you do on Thursday, the 20th of April? I couldn't tell, Your Worship, if you ask me. So I think that paragraph needs to be read in that light. But once again, Your Worship, how far do we go into the merits of the state case against an accused in a bail application when this isn't a trial?
Yes, I agree with you. I agree with you, but the concerns have to be raised and interrogated, because if he took the stand, he was giving viva voce evidence. He would have been cross-examined and he would have accounted. But in this case, we are faced with an affidavit which cannot be cross-examined.
Absolutely, Your Worship. And the investigating officer would have been cross-examined all day.
Exactly.
You say 800,000 rand is paid for a hit, but you don't arrest the person who paid the 800,000 rand. Why not?
But
It cuts both ways.
right now, we're not talking about the investigating officer. We're
No,
talking
you-
about the applicant number 4. Let's wait until we get to the investigating officer.
Your Worship, please.
Yes. Let's wait until we get to the investigating officer and ask those questions to the investigating officer.
Thank you.
Right now, we're talking of
Yes.
the applicant in this case, who bears the duty to show on the balance of probabilities.
Yes. Exceptional circumstances.
So let's not jump to the investigating officers yet. Paragraph 63.
Yes, Your Worship.
The state alleges that applicant number 4 was requested to submit his cell phone.
Correct.
And that request was extended to his attorney as well.
Correct.
According to the state, I don't know, I was not there.
None of us were.
Otherwise, I would not be sitting here.
Yes.
Applicant number 4 refused.
Yes. That is
And
what the state says.
can I finish?
Sorry, Your Worship.
And applicant number 4 says in paragraph 63, all the exhibits the police would like to use against me to prove the charges are in possession of the state. And yet there is these allegations made by the state, the cell phone which we have requested a number of times from the applicant and from his attorney, we're not in receipt of that. He refuses to submit that.
I hear Your Worship. But Your Worship will no doubt have regard to his response to that. And that is, I don't have it. It was at home. The police raided my home. Your Worship has been furnished with the USB showing the beginning of that raid.
But that is not contained in his reply in affidavit. That reply you are giving now is not contained in his reply in affidavit.
Your Worship will bear with me.
Show me if I missed it.
I may have a moment, please.
Certainly.
Reply and affidavit.
That is exhibit M.
Page 10, Your Worship.
Page 10.
Paragraph 52, Your Worship.
No, it cannot be paragraph 52. Page 10 has paragraph 28 and paragraph 29.
I apologize for that. Can I take Your Worship to paragraph 52 then? Hopefully the paragraphs have remained the same. To ensure that Your Worship and I are on the same page, literally,
Yes.
it's the
It's
paragraph that
paragraph
says much is made.
Page 17.
Thank you, Your Worship.
Yes, thank you very much. I missed that.
Your
And
Worship,
it is
please.
stated here, counted. Much is made of the alleged failure to hand the cell phone to the police. This is untrue. Yes, no, that is accounted for.
Yes, Your Worship, please.
Thank you for There are allegations by the state that applicant 4 was the coordinator
Yes.
of the hit
Yes.
man.
Yes.
He was the mastermind.
Yes.
That suggests, or the suggestion by the state is that this was the work of a gang.
I've read that, Your Worship.
Yes. Now, if that is true, I'm not saying it is true, it is an allegation, will that not cause a stir in the public?
No, Your Worship. Firstly, it's an allegation that has been denied by the applicant. Secondly, it's always been my submission that there is no one more optimistic than an investigating officer or a prosecutor. So no, that allegation is denied. Furthermore, there's no evidence, not a bit of evidence put before Your Worship to indicate that if Your Worship, for example, granted bail, there would be a public outcry. There is nothing. No evidence. Only a submission, not based on anything factual.
On his replying affidavit, applicant number 4 state among others that the state case is just a conjecture.
Yes.
And there is no substance in the state case. Now, my question is, there is evidence in the affidavit by Pillay that he was found in possession of the witness statement, the original witness statement in his vehicle recovery hold, the witnesses that were to testify about the vehicles.
The BMW, when it was taken by the police for
It's
investigation.
two witness statements. I'm not looking at today's statement right now, but there are two witnesses whose statements were found in his vehicle's cargo hold.
Yes.
Now the question that begs is, what are the state's witnesses' statement doing in his possession or in his cargo hold?
Well, Your Worship will recall that the BMW was taken by the police, was taken from a third party. Obviously, accused number 4 has to then explain, well, you had the BMW, it was taken from these people, or taken from investigation. So I would submit there is nothing unnatural in trying to get to the bottom of it. And in fact, if anything, it indicates a tendency to want to cooperate with the police.
But wait a minute. Let's look at Pillay's affidavit. I'm not saying he is telling the gospel truth. Whatever he's saying is true. But let's read and understand it. Witnesses XY approached me and asked for their statements. At the time, I did not know why they wanted their statements. It's only later on that I learned that they asked for their statement from me because such statements were demanded and asked for by applicant number 4.
Yes.
That is what Pillay is saying.
Yes.
Whether he is truthful in saying so or he is making up the case, I don't know. But that is what is contained in his affidavit. So if it is true, what is it?
Well, Your Worship, I'm not in a position to argue, make out an argument based on the investigating officer telling the truth when our affidavit says something different.
But you had an opportunity, if I say you, I mean you on behalf of applicant number 4, you had an opportunity to reply. Did you reply to that? If you
I
did,
believe so, Your Worship.
take me to that particular
Your Worship,
paragraph.
bear with me. Your Worship, I'm not going to mention pages because I'm getting them wrong and I'm not on the same page as Your Worship. But I'll take Your Worship to paragraph
Paragraph
56.
56.
And while we're in that, on that paragraph, Your Worship, my instructing attorney is not the attorney made mention of them. Different attorney.
You say paragraph 56.
56, Your Worship. Paragraph 56, and it starts, the heading is ad para 234.
But paragraph 56 speaks of the affidavit that your client made to the police. I'm not talking about that.
No, Your Worship, but this is his reply to what Pillay has said, and incorporated in that was what Your Worship made mention of.
Okay, so you say that is the answer.
That is the
to,
answer.
To my question.
Yes, Your Worship.
Okay. You're not under cross-examination. You're not supposed to be answering the question. You are assisting me to allay the concerns.
No,
that
of course,
I
Your Worship. Of
I
course.
accept what you're saying.
So, Your Worship, that is his answer.
Okay.
But once again, my submission is it doesn't impact on his application for bail. It is not an indication of tampering with evidence. It is not an indication of intimidating witnesses. And it's not an indication of destroying evidence or that he will abscond. Even if Your Worship were to accept the investigating officer's affidavit, as Your Worship calls it, as the gospel truth.
No, but wait a minute.
Yes.
Since when is a suspect entitled to witness statement?
Well, Your Worship, under circumstances...
Before those statements are given to him by the state.
But he wasn't a suspect then.
I beg your pardon?
He wasn't a suspect then. We're not talking about statements from this docket, Your Worship.
One other thing that raises a question
Yes, Your Worship.
is the allegation by the state that his cell phone places him at the airport, it places him at the scene of the incident when it occurred. His cell phone places him at the garage in Umlazi, where, or rather at Umlazi, where the vehicles used and the weapons were retained.
Yes. And Your Worship's question is?
Does he address that?
Yes, he
in
does.
his reply?
Yes, he does.
Okay. Assist me.
So, paragraph 13.
Is this now his reply in affidavit?
Correct, Your Worship.
13.
In fact, 13 and 14.
Yes. I think we work better if we speak of paragraphs than pages.
Yes, indeed, Your Worship. Paragraph 15 and 16. Paragraph 20 and 21. Paragraph 22. Paragraph 41. I think that is all, Your Worship.
Thank you. You have referred to, I think, KP1 of Pillai's.
Yes, Your Worship.
Looking at that consolidation, can you confirm that the money is paid in, that is the 803,455 rand is paid in at 1400 hours at 2:05, so to say?
Yes, Your Worship.
And,
that is what this annexure says.
Yes. And the large portion of that amount is paid out at 8:05. If we look at the last entry to St. Benedict School.
Yes, Your Worship, but Your Worship is forgetting at 18 hours 22 and 19 hours as well, which are monies were paid out between that time. So basically, I hear Your Worship, I understand where Your Worship is coming from. It's between 6 o'clock and 8 o'clock.
Is that within a short space of time?
Correct.
We calculate 2, 3, 4, 5, 6, 7, 8 within 6, 7 hours.
Yes.
This large amount is paid out.
Yes. But that is the nature of the applicant's flow of money. Sometimes he gets large amounts, and then there are lean periods. A bit like advocates, we're poor one day and wealthy the next day.
I'm just noting that because you refer.
I understand.
Thank you very much.
As Your Worship pleases.
That brings us to the end of the head's argument on behalf of the applicants. Now we have to invite the state, and I've already stated I could only get the hard copies or have a look at the heads by the state this morning, and the font is very small. One cannot quickly go through it. Because I want to take them on as well. There are a number of things that I would like them to explain to me and assist me. So I may not be forthcoming as I should be, but I will try my best. Mr. Kaba.
Thank you, Worship, for the indulgence. I seem to have a proposal for Your Worship, subject to what my learned friends say. Without getting into the merits of the reasons, there were several exchanges of emails between the 19th of April up until yesterday, relating to the delays in why the state could not file their heads on time, inclusive of the fact that some of my learned friends were of the view that I was not supposed to see the heads, they were only for your eyes. The record will then reflect that we were delayed, or the delay in submitting our heads was occasioned by the misunderstanding in between the parties, as well as the fact that we only received the last heads of one of the applicants at 5 o'clock in the morning yesterday. That made us to file, and the parties have been kept abreast as to why there is a delay. In all fairness to the applicants, if the matter may be enrolled to allow your worship to properly study the heads of the argument, whereby I would be saying to the court, paragraph so and so is saying the following, in the context in which the court must understand those heads but not be proper if the court have not studied the entire heads of argument. However, that is one request. Insofar as how I was thinking of approaching my submissions, one was to first reply on what has been said today before I go to my heads of argument. Therefore, we would not have wasted today's time in me or us making submissions today if we reply to what is being said. But before I take your worship to what we are saying in our heads, that can be done on another day, seeing the fact that my colleagues might want to reply to whatever I'm going to say. And looking at the time, we only have 40 minutes left to do all of that. That is my proposal. Like, I might say a few things on what has been submitted by my learned friends this month. And then insofar as what the state thinks should happen, we can leave that to another day where the court has had time to study the heads of argument and also to allow my learned friends to reply to whatever I might say. That is a proposal, subject to what my learned friends are saying.
We started with this bail application on the 14th of March. We are now into May. Bail applications are supposed to be urgent and supposed to be disposed of as soon as it is possible. But we have taken almost 2 months because of the availability of your good selves. Next week, I'm not available the whole of next week. I'm involved in something else that will take me the whole week from Monday to Friday. I hear what you're saying, but that is the problem. Unless if we were to say the matter is rolled over until tomorrow, then I can make a few phone calls to say that where I'm supposed to be tomorrow, I will not be, but hear these arguments. I don't know, I see most of you are nodding. I don't know whether tomorrow sounds good to most of you.
Suitable to you.
The difficulty we have with the of 1 and 5, as we submitted our heads of argument, that is why before the commencement of the proceedings, we have to enter into a memorandum of understanding as counsels that the heads of argument will form part of the record as the exhibits, and as parties we will only draw the attention of the court to those aspects we think are significant. That is the reason why even for applicant number 1 and 5, if one looks at the heads of argument, I did not give a blow-by-blow account of what we are submitting on the basis that the heads of argument are part of the record. Regarding the further conduct of the day of the matter, Your Worship, in chambers we traversed our diaries. It became so apparent that our diaries are messed up in terms of commitments. Tomorrow I'm at the LPC, my instructing attorneys are not available, and from next week onwards we've got a 2-week trial upstairs. So the request my instructing attorneys had made is, even if there is a need to reply, in the light of the fact that the issues have been ventilated, we can't exceed a minute or two if we were to reply. That is why this morning I was instructed that not to go the heads of argument blow by blow, so as to accommodate all the parties in the matter, at least today, to conclude our submissions. I fully understand the predicament my colleague for the state is having to, but the issue is the diary, and as already the court has indicated, otherwise we would have come this morning and requested a postponement on the basis that the heads of argument from the state were received late, but we never made noise because we all wanted the matter to keep the ball rolling.
Yeah, maybe I had so many questions and I was too talkative. But this is bail application and the proceedings are inquisitorial, so I had to ask these questions. Now, so you are not available tomorrow?
Yes, maybe if the matter can be stood down so that I can also make a call, and maybe for 5 minutes.
Yeah. Ms. Gilling has indicated she's available. Mr. Jefferson?
Your Worship, I can make myself available. I think it is in the interests of justice that Your Worship have sufficient time to properly consider the state's submissions, so that Your Worship, if needs be, may be able to interrogate them properly.
It's unfair to interrogate one party but not the other. Mr. Volmarans?
Your Worship, I am available tomorrow.
Unfortunately, Your Worship, I am available.
Okay,
No, we'll make ourselves available, Your Worship. We'll just also make a call that arrangements be made.
Let's allow a call to be made. I also need to make a call.
Yes, Your Worship. We can take until -5 to 3. We can come back at 3:10. Yes.
Don't you want to pass them on to Milady? I'm short exhibits. Short exhibits.
Exhibits. All the exhibits are with the magistrate.
No, giving it to you to get copies next time or the time after it when we have time. How do you copy or to scan?
The unfortunate part is, I think he leaves the exhibit every time he goes. I don't get it. Unfortunately, I don't get the exhibits. As they finish now, the magistrate all the exhibits. He takes them again. They don't leave us the exhibits.
So when do I get them?
I literally at the end of the, after you've done them, then you do them here. Yeah. Maybe at the end of this.
I'm ready. She was very Don't make excuses for her. Just say, I'm not here. If she says, can you stand and say, no, send him back to the
That is now if your worship is available tomorrow.
I am available tomorrow. I was hoping that I was going to suggest that you start as early as possible, latest 9 o'clock. Now, 11 o'clock is
May
the
I
direct
approach Mr.
opposite
Mlotshwa?
of what I had in mind.
Your Worship, obviously, I'll have to adhere to the court's directive and comply.
You see, my view, without pointing a finger at anyone, we are in this situation because this court has never started at 9. That's why we find ourselves in this situation. But I'm not criticizing, I'm not pointing a finger at anyone, but that is the fact of the matter. Even today, we did not start at 9, nor did we start at 10. I think we started around about 11 o'clock.
Yes,
At which time we could have covered a lot of ground. But I understand we are all trying to sacrifice, we are all trying to make it work. If it means that we cannot but start at 11, then we'll have to start at 11.
Sorry, I think Mr. Mlotshwa did say if the court directs him to be here at 9, he will be here at 9.
All right, then Mr. Mlotshwa, please be here at 8:30 so that we start at 9.
As court pleases. As court pleases.
There are a lot of witnesses to this directive.
So, yes.
And a lot of complainants who might open a case if he's not here at 9.
The 2 of us as well.
So the matter is therefore rolled over until tomorrow for further evidence or further addresses. Tomorrow we are not starting at 9:05, but we are starting at 9 o'clock. Please, those who are assisting us by bringing the applicants from where they are kept, please, they must make sure they are here at 8:30 so that we start at 9 o'clock. Thank you.
Before we adjourn, we wish to make a small submission on a lighter note. We apologize for the small font in the heads of argument. There's a national instruction that you must save as much as possible. We are trying to save the printing paper as much as possible.
That's national directive to our prejudice.
Apologies.
I'm already wearing glasses because of the small fonts. Thank you, gentlemen. We'll see you tomorrow.
Let me do that. Let me. You know what, Jeff? Audit? What if, you can make a couple of times. You can't cap, you can buy us.
Rest of yes.
I can expect.